There were some studies done in the last couple of years about the sorts of cases in defamation that make their way through Australian courts, and they've found that the majority of cases these days involve just regular people slagging off one another on Facebook, on Twitter, on whatever else. These cases are increasingly common, and this wasn't too an unusual outcome today. The poster, the author of the comment, is obviously responsible for what they say, whether that's in defamation or whatever else, and those authors are often the people who are sued. But defamation law isn't about authorship. You can be sued as publisher, and a publisher, for example, it might be someone who makes it possible for others to say things. This is why, for example, newspapers might get caught out for letters to the editor. So what was somewhat unusual about this case is that it seems that the person who settled is actually the owner or the administrator of the Facebook group. That's the person who set up the group. And as I read it, it sounds like she didn't even write the content in question. So this decision is an example, potentially, of a trend in recent months based on the Dylan Voller case, where individuals, whether companies or humans, who provide a forum for other people to make defamation, those people can be held responsible even though they don't write it themselves. All of these platforms have terms and conditions. They're those long documents that none of us read, myself included, where you just click I agree, and buried within the stuff that you agree to is content saying you will be nice to others, you won't engage in hate speech, you won't infringe intellectual property, all those sorts of things. So everyone would be agreeing to this, but they probably just are not aware of it. So whether more needs to be done on the part of Facebook and Twitter to regulate what happens through these platforms through which they make huge money, that's a really live question and one that is being discussed right now by lawmakers. For a few years, New South Wales has led a proposal to reform the acts in each of the states and territories of Australia, basically to readjust the balance between giving effect to freedom of expression and protecting reputation. The argument that's put forward by many is that the balance isn't right at the moment. The media, for example, and by that I mean media companies like News Corp, they often argue that media freedom in Australia is unfairly being eroded by defamation, amongst other things. So one of the things that these reforms might do is make it a bit harder for people to sue, to make it a bit of a higher standard of damage is necessary before you can go away and sue someone in a court. We're yet to see the fine details of what exactly the law reform will look like, but we'll probably get a clearer picture next week. So once upon a time, maybe a decade ago, it was fashionable for academics like me to write about defamation on the internet, whereas these days that sounds a bit stupid because defamation is the internet. The internet is everything. So of course we're seeing more and more cases of defamation involving social media. I think the study from 2017 produced by UTS in Sydney said more than 50% of cases these days involve social media. That trend no doubt will continue, and it was very different a decade or two ago.